This is case number 2006-0113, Frederick J. Murray versus Special Investigation Unit of the Division of State Police of the New Hampshire Department of Safety, et al.
Counsel, before you begin, there's someone in the courtroom this morning that I would like to acknowledge and to tell him what an honor it is to have him in our courthouse. And that is the Chief Justice of Iraq, Madhat al-Mahmoud. He spoke here the other evening and left a lasting impression on all of us. And so thank you, sir, for being here this morning. Counsel, you may proceed.
Thank you, Your Honors. Good morning. My name is Timothy Irvin from the firm of Gallant & Irvin, and I represent the appellant in this case, Mr. Frederick Murray. The issue before this court is an appeal under the New Hampshire Right to Know Law, RSA 91A, of a decision issued by Judge Vaughn denying Mr. Murray's request to obtain records under the provisions of the New Hampshire Right to Know Law and under its federal counterpart, FOIA. And we suggest, Your Honor, that this is a unique position we find ourselves in. The typical cases involving the disclosure of records under 91A typically involves situations where a number of records have been produced and a limited number of records have been withheld by the state under a claimed exemption to the Right to Know Law. And in this case, the entire 2,500 documents that the state claims to have in its possession, none have been produced on the grounds that all of the records fall within a claimed exemption to the New Hampshire Right to Know Law and FOIA specifically. The position of the state is that all of the documents are in an investigatory file and therefore need not be produced. And I would suggest that if the court follows that reasoning, the exception would swallow the rule. This court has been very clear in its decisional law that the balance should be that exemptions are narrowly construed and the provisions favored disclosure are broadly construed.
Is it your position that the state has to make a specific showing in this case that disclosure would interfere with an ongoing criminal investigation?
It is, Your Honor. I believe.
How would the state do that without compromising whatever information there is in the file?
Well, Your Honor, in Loge, which was the first decision of this court to deal with records of this type, the investigatory records, the court stated at a minimum there should be an in-camera review of the documents that are in the possession of the state so that they could articulate what exemptions apply and how the release of the records would be implicated by one of the exemptions. And in
Who
this
would you
case,
have perform that review?
I'm sorry?
Who would you have perform that review?
That would be done by the trial court. In Loge, it said specifically that on going forward on cases, the trial court should require an in-camera review with the judge and counsel to determine that the records that the state is claiming are exempt, in fact, comply and meet with the exemptions.
Why wouldn't that, in those pre-indictment circumstances, why wouldn't that almost be presumptive?
Well, Your Honor, there certainly will be records in the state's possession that would fall within one of the claimed exemptions, but to suggest that all 2,500 records that the state has compiled all fall within that exemption.
The concern, I suppose, is this. What if, with all the investigations underway in the state of New Hampshire, however many there are, but there are multiple, I'm sure, a member of the press said, I would like to get access to those materials, and I don't trust you, so I'd like you to do a Vaughn index or have an in-camera hearing, and we'll go through every single document, and you can justify it. We probably wouldn't have enough time in the courts to deal with that, would we?
Well, Your Honor, I would suggest that there is a balancing that can be struck.
Yeah, but in every individual case, they'll say, well, you can strike a balance in the next case. But you're suggesting that if there's investigation file, the state, document by document by document, in camera, has to explain why it would be prejudicial to release it?
The decisions from this court and the federal courts have stated that it is incumbent upon the state authority to make an examination of all of the records in its possession to determine whether or not an exemption to FOIA or the Right to Know law applies.
But if that's true, then in every case when they say we're exempt because they're investigatory files, pre-indictment, you would say, or whoever has the case, well, thank you for sharing that, but I'd like you to do a Vaughn index, or I'd like to have an in-camera review, so bring the 1,400 pages, and the judge will set aside a day or two and go through them. Is that what you are saying?
I believe that's what the New Hampshire right to know law requires, and I believe that that's what FOIA requires. I believe that the statutes are designed so that there is access to the records of what the government has done. And this court in the Baumann case was very specific when it stated in its language that they were not adopting a per se rule favoring non-disclosure. What it was saying was that in Baumann, because we were at the crucial early stages of the investigation was only 5 months old. It was a very limited number of records that they were seeking. They were seeking the search warrants and the affidavits that were used in conjunction with that. And the court in that case said that you could temporarily withhold those documents.
Well, is it just the 5 months? Is it just the time limit that matters? In other words, are you suggesting that because more time has passed with little apparent development, suddenly the balance shifts?
Well, the balance, Your Honor, is always, my understanding, is always on the state to show that the exemption applies. In this court, in Baumann, used the language.
Baumann, the state showed that the exemption applied, but you seem to think that the passage of less time may have been a critical factor for the decision.
I believe that it was a critical component of this court's decision, and that's why they used the language that in Baumann they said that they would restrict access for a temporary period of time so that the state could have a reasonable amount of time to conduct a proper criminal investigation. In that case, it was 5 months.
What's reasonable?
I believe
you would say that this is not reasonable?
We're coming now, Your Honor, on the third year anniversary of Maura's disappearance. Has the state had sufficient time to conduct a proper investigation into her disappearance? I believe that they have. I believe that there still will be records that the state could show will fall within an exemption, but to suggest all 2,500 records when there has been zero examination of any of the records in their possession to show how these exemptions apply. This was basically what has happened here, and is what the Supreme Court in the National Labor Relations versus Robbins case said, was simply to needlessly extend a prohibition against the release of any records simply because they're an investigatory file is not in keeping with what the mandates of FOIA are.
Do we know what the state means by ongoing investigation in this case? Do we know what actually is being done?
We do not. The testimony at the lower court was on an offer of proof that there is an officer that examines the case every day.
Is this a criminal investigation?
I don't believe that is clear, Your Honor, because the characterizations of the state when Maura first went missing was that there was 3 theories they were proffering: that she went missing of her own volition, that she had succumbed to the elements, or that she was a suicide victim. And so,
does it make a difference if it's a criminal investigation as distinguished from a missing person?
I believe there is a distinction. The distinction is when, under FOIA, records can be withheld if there's a concern in what the state has raised here that it will affect an enforcement proceeding. So if there is not an ongoing criminal investigation, then the fact that the release of the records could implicate or impinge upon a future enforcement proceeding is speculative, because there is no intended enforcement proceeding at that time. In the court in Eli versus FBI, Your Honor, dealt with this very issue, and also in Chicago versus ATF. In that case, the city of Chicago had requested records from the Alcohol, Tobacco, and Firearms Division. They had assembled records in a database on handguns that had been used in crimes in the city of Chicago. And in that case, the city sought to get access to the records, and the Seventh Circuit required ATF to turn over the records on the finding that to suggest that at some future time they could prosecute an individual based upon the guns that were located in that database was speculative.
Isn't that a factual finding? In other words, as I understand this case, and if I'm wrong, please tell me, I thought that the state had given to the Superior Court a listing of the types of documents involved. Did they do that?
Your Honor, page 100 of the appendix, the state produced a one-page document that has 20 vanilla categories of records that are contained therein without any specificity as to how each of the records which would fall within those broad categories fall within the limited exemptions under FOIA and the right to know.
Your view is that on FOIA, for example, no court has ever made a ruling on this exemption or been allowed to make a ruling on this exemption without a Vaughan index and some sort of in-camera hearing, document by document by document.
I'm not suggesting, Your Honor, that has never happened. There are certainly the Dickerson case
Is that the usual way these cases are resolved, or is the usual way the way it's resolved here? In other words, the court made a finding here, as you know, that it would likely interfere. And it seems to me that's a factual finding, and you're saying the court did that on inadequate information. And my question is that how it generally occurs? The law enforcement authority says these are the types of documents we have in our file. To disclose them now would interfere with our investigation of this crime. And the courts say, I accept that, or I don't accept that. Is that how it generally happens?
My understanding from reviewing the cases, Your Honor, in the Cucci case versus FBI, in Eli versus FBI, those cases speak specifically to the exhaustive search that was done by the underlying departments, FBI, DEA, to comply with the requests that were made to those organizations. And then it talks about the significant, they always list the number of records that have been produced, and then talks about the narrow number of records that are not being produced under some claimed exemptions. And the court make note of affidavit testimony. It takes testimony from witnesses that were in charge of assembling the records to show the detail that these various agencies engaged in order to show that they made an exhaustive search to produce all records which were not exempt, and to show the good faith basis to suggest why they've met those specific grounds which would prohibit disclosure. And in this case,
let's say, for example, there are reports on physical evidence that was recovered, whatever it is, and the state says we have reports on physical evidence that was recovered, and if we release this, it would interfere with the investigation. Is that sufficient?
I would suggest that they've met their burden at that point in time, Your Honor.
And how about if they say, well, we have witnesses that we've interviewed, and they've given us information. If we release that, it would interfere with the criminal investigation. Would that be sufficient?
I would think that it's still, Your Honor, I would think that at a minimum there should be some sort of in-camera review to suggest.
I don't want to get to in-camera review yet. I'm saying that, so you're saying that would not be sufficient if the state says the witness interviews would compromise our investigation?
I would think that the burden, and it's clear under the case law, the burden is on the state to show how the exemption applies, and it would be up to the reviewing court to determine whether or not the state has sufficiently met its burden to show.
But you're saying on my hypothetical that would not be enough?
In some instances, it would not be enough, Your Honor. It would be.
So a court gets involved in making qualitative judgments about the nature of the prosecution at that point, and what is prosecutory or what is investigatory and what isn't. Isn't that an impermissible intrusion? If we are dealing with a criminal investigation. Say witness interviews. And again, I think that is why this court in Loge said at a minimum that there would be this in-camera review. One of the cases that was cited in my brief that I would like the courts to consider is that Eli versus FBI case, where it was the exact same case in front of the 11th Circuit, where the state had denied access to any of the records, had provided no Vaughn index, had provided no list of the types of documents it had. And the 11th Circuit said in that case, where you had simply no hearing, no minimal showing of how the claimed exemptions applied, no in-camera review by a court, it gave the government an unfettered check, and the 11th Circuit found that violated FOIA, that at a minimum there needed to be a review and the state to establish how, with specificity, how all of the records that they claimed were exempt fell within the exemption.
On page 100 here, where the state disclosed categories of records, without asking you to go through those, are some of those on their face acceptable to you, or does the court have to get a Vaughn index on every category listed?
Your Honor, it's difficult to say because, again, if you look at the categories of documents here, phone records, it's a generic term. There were a number of phone calls that Maura made prior to her disappearance. And the burden is on the state to show calls that they would have in their possession that predate the disappearance and any investigation fall within the claimed exemption. That it's difficult or impossible for us. And the burden isn't on Mr. Murray to establish that the exemption in fact applies. That burden falls upon the state. And without having had any meaningful review by a reviewing court to suggest how these various categories of documents all fall within the claimed exemption.
How many documents are involved here, do we know?
My understanding, the representation, Your Honor, at the trial court was the state had assembled 2,500 records.
Okay. So just so I understand what you envision a hearing held. You're not at it?
I'm sorry?
You're not at the hearing in camera? Who's at the hearing?
My understanding that the in-camera hearings are conducted in the presence of counsel, Your Honor.
So you're
the trial judge.